right, welcome. We are starting our latest chapter, and that is chapter 9. We're going to be looking at the adversarial system, and we're going to be looking at in action how it works. And of course, the adversarial system is fundamental in our discussion of the court system. For those of you who aren't aware, and I know I repeat this information at the beginning of every lecture, but this is the PowerPoint for Chapter 9 in Criminal Justice in Action by Gaines and Miller. This is the 11th edition we're covering here. These are being recorded in June of 2022 for Introduction to Criminal Justice, CJC 111 here at Wake Tech. Probably be useful for about the next year or so till a new edition comes out or till I revise my notes. Okay, so I start every chapter with certain questions because I want students to think about things that either the chapter omits or chooses not to cover intentionally. Omit kind of has the inference that it was accidental. So here are some questions I think that are important as we start to study the adversarial system. One, why do we elect prosecutors but not chiefs of police or as we elect judges? So we elect prosecutors, but we don't elect our Supreme Court of the United States, even though they're extremely powerful. Why? If trials are disappearing, and we're going to talk about how trials are or not disappearing, should we have new rules? In other words, if a system has grown up with the idea that everybody's going to have a criminal trial, but that's no longer true, maybe it's time to look at the system that has kind of grown up in its place without intention, maybe not, maybe with intention, and ask, do we need new rules for it? Why is bail set to money and property as the primary guarantee? Why aren't there other alternatives? Why do we think property is so important here? And this one I kind of threw in at the end, and there's a legal maxim, and it's kind of cutting and it's kind of untrue, but nonetheless I've heard it most of my professional career. Don't trust your life or your property to 12 people too stupid to get out of jury duty. Why do we think that 12 people will make a better decision than one person? Are 12 people smarter than one person? What is special about a jury? You know, is it something that many people try to get on or many try to get off? What is it about it that we were going to make it, or we do make it, the repository of justice in our system? Okay, again, we have those learning objectives. You do not have to know them. They're really just to talk about general themes and concepts in the chapters. Okay, I had to put Sam Waterston there from Law & Order. I think if you're an American and you have watched any TV in the last 20 years, and I was to make the noise, dun dun, you would, maybe if you didn't watch the program, you'd be aware of Law & Order. And Sam Waterston there plays the assistant district attorney. I think he eventually in the series gets elected district attorney, and he becomes kind of the ideal that we think about. And he's a pretty common figure in American literature and drama, where you have the honest, dedicated prosecutor, primarily interested in his idea of justice. Maybe not everybody's idea of justice, but he's got an idea of justice. So I thought he was a good representation of what we expect. The prosecutor has a fundamental duty of fairness. Now, in this sense, he has a greater duty than the defense attorney. The prosecutor is supposed to seek justice, and that's usually served, from his point of view, by a conviction. But in practice, that's probably not always true. I mean, he should be able to look and say, well, yeah, I would be able to convict this person, but they probably didn't do it. So that would be wrong. I shouldn't seek that conviction. Now, a defense attorney who said, wow, this guy probably committed the crime, but I can get him acquitted, I have as a defense attorney, fundamental duty of fairness to say, well, can't represent him in that way. Part of this we see in something called the Brady Rule. So what's the Brady Rule? Because most criminal trials, you have the prosecutor there, and you have a defense attorney who is appointed by the government, assigned counsel or public defender. They're not going to have a lot of resources. So who's got all the resources to do investigations? Well, the prosecution does. Who has all the witness statements? The prosecution does. Who has all the ballistic evidence? The prosecution does. Who's got the blood evidence? The prosecution has custody of it. So he's got all the evidence. And in the case of Brady versus Maryland, a Supreme Court case, the Supreme Court said that in the prosecutor's files, if they have evidence that shows an individual did commit the crime or did not commit the crime, and we call evidence that tends to show you committed a crime inculpatory, it puts you in prison, and evidence that keeps you out of jail is exculpatory, EX, or no longer, it won't put you in jail. So the prosecution has all this evidence. Now some prosecutors are excellent. We used to have a prosecuting attorney here in Wake County. He was the chief district attorney. His name was Colin Willoughby, and he practiced basically open files. If they had a piece of paper in the file, the defense attorney could have it. Some prosecutors guard their files much more zealously, and they decide what is or is not important enough information to give to the defense. And there might be a piece of evidence in there as a defense attorney that I think, well, I'd love to have that. That cast doubt on the prosecutor's case. But the prosecutor says, nah, it's from an unreliable witness, or it's hearsay, so I don't have to tell the defense counsel about it. It's pretty much up to the prosecutor to obey the Brady rule. There's really no way, since I don't know about the existence of information that the prosecution might have, that I can force him. I can't say, well, give me that statement of that witness that says my guy didn't see the shooting. I have no power to do that because I don't know it exists. Okay, the office of the prosecutor has the most discretion of any figure in our system. They decide if someone who gets arrested will be charged. Now, sometimes the police make mistakes, and someone gets arrested, and the prosecution looks at it and says, wow, you just didn't have probable cause for this. We're not going to charge this guy. We're going to kick him loose. If they are deciding on a charge, they decide what level. Is it going to be a felony? Is it going to be a misdemeanor? They're going to decide how many. Is it going to be 1 misdemeanor, 2 misdemeanors, 10 misdemeanors? They decide when to start prosecutions. Yeah, we need to go forward, or when to stop them. Hey, we don't have enough evidence. We need to pull back. So the prosecutors in the United States, the chief prosecutors, are all elected. So if we look at North Carolina, we have 100 counties. In these 100 counties, each county elects a prosecuting attorney. Now, having said that, there's some states, and I think North Carolina, as a matter of fact, might have some counties that have multiples, but every prosecutor is elected. Now, after he's elected, he often, suppose he's elected here for Wake County, which has more than 1 million people living in it, or Charlotte, which has more than 1 million people. Now, obviously, he can't handle every prosecution, so he will hire what are called ADAs, more about those in a second, assistant district attorneys, and those will do a lot of the work. The Office of Prosecuting Attorney, district attorney usually, is seen as a stepping stone to higher office. So one of the things that happens in North Carolina very frequently is the chief prosecutor for the state of North Carolina is called the Attorney General of the state of North Carolina. He often becomes governor of the state. So Roy Cooper, our current governor, used to be the Attorney General of the state of North Carolina. And I will bet, we're 2 or more years out from the election, but the current Attorney General of North Carolina is a man named Josh Stein. He's a Democrat. He will probably run for governor. I'll just about guarantee it. Not positive, I'll guarantee, no, pretty close. And so it's just really common for someone to become prosecutor because you get your name in the paper, you can become relatively famous, and then that is a stepping stone to being governor. They also respond to community pressure because they are elected officials. They have to answer to the public and to their political party and to the media. Is the media making a big deal about something? Whether it's truly an important issue or not, the prosecutor will often respond. Prosecutors cooperate closely with the police. This limits their neutrality in evaluating police actions. Now, they don't directly control the police, except perhaps at the federal level. You could say the Attorney General of the United States is the boss of the FBI, and they're essentially a police force. But at the state level here in North Carolina, the Attorney General doesn't have his own private police force. The district attorney of Durham County can't tell the Durham County Police Department what to do exactly. Having said that, they have very close relationships, and they get all their evidence. Those police will not talk to the defense attorneys. They will talk to the prosecuting attorneys. One of the things that when we talk about the police here is the police are focused on factual guilt. They don't care whether something can be proved in court or not. What they care about is, did someone commit the crime? Now the prosecutor has to focus on legal guilt. What can he prove in court? And again, not common, but let's suppose it happens. Let's suppose the police beat a suspect till he confesses and he says, yes, I robbed the liquor store and the money is hidden in the attic of my house. They go to the attic of his house, there's the money. Okay, well, they can show factually he did it, but the problem is that evidence is going to be inadmissible, both the money that is found and the confession. So the prosecutor probably can't prove in court that that's the individual who committed the crime. Prosecutors also have relationships with victims. They're seen as being on the same side. So if you have a horrific crime like a rape or a murder, or attempted murder, the victim of the rape often will look at the prosecutor for justice. They are seen, and it can be really important that the victim is seen as sympathetic or someone that is worthy of this. Now, there's nothing explicit in the law that says that, but let's take a classic example. Let's suppose two different individuals go missing in a large metropolitan city. One of those individuals is a 40-year-old street prostitute. She was last seen at 11 o'clock at night on the corner of 5th and Main, wherever that is, fictitious city. She also is a drug addict. She also, has had numerous arrests for petty misdemeanors. Okay, she goes missing at midnight. Now, contrast that with little Cindy who lives in Whoville in a nice little house, and she's a cute little girl, and she's got little pigtails, and she plays hopscotch out front, and she disappears at midnight. Now, who do you think is going to get, first of all, more attention from the police, and can you see there would be much more pressure for a district attorney to zealously prosecute someone who kidnapped a child versus someone who kidnapped or took hostage or killed possibly a prostitute? The prosecutor in North Carolina has immense power. The first thing the prosecutor can do, and this is North Carolina General Statute 7A-71, is he controls the calendar. He basically sets when cases go forward. Many people think it's the judge, and in many states it is, but not North Carolina. He controls if a charge is going to be filed. So there's no citizen's arrest in North Carolina. You don't press charges. You can go down to magistrate and ask, but it's pretty much up to the DA to go forward. He decides if something's going to go to trial. He'll look at the evidence, decide should I go. He'll decide, all right, I'm going to drop charges or not drop charges. He controls the police investigation. He might tell the police, look, you need to find me another witness. The one you provide is no good. He has a large staff, typically, and he has massive resources compared to the average defense attorney. In North Carolina, they're called district attorneys, or again, if they hire someone, it's ADA or assistant district attorneys. There is a breakdown of the different prosecutorial districts. Now, I said I had misspoken earlier. because I've mainly practiced in large counties, and you can see the large counties there, like Wake and Mecklenburg. There's going to be a single district attorney in those counties. But in some of the smaller counties, you'll notice, I actually should have known this because I did practice up in Mitchell County, and that's up in the mountains there. You can see that kind of, there's, I guess there's five counties strung together. There's one district attorney for all five of those counties. And that's pretty common because if you go outside of the major cities in North Carolina, there's not a lot of population compared to the cities. So we have 43 prosecutorial districts. And you can see that most of them are centered on a large town like Raleigh having its own, or Mecklenburg having its own. Okay, the defense attorney, let's talk about them. And this is what I did most of my life when I practiced law. The primary duty of a defense attorney in a criminal trial is to represent the defendant. I have a few other duties, but I represent the guy who gets arrested. Now, one of the things I do is investigate facts. Now, it's not uncommon for defendants to be less than truthful with you. So they might say, I've never been arrested. Well, one of the things I will do, even if a client tells me that, is I will investigate their arrest record. I will see if they've been arrested, and then I might say, hey, it says here that you have 17 traffic tickets. Well, those weren't arrests; they don't count. Or it says here that you were arrested in Virginia. Well, I thought you were just talking about North Carolina. So I will investigate facts. I communicate with the prosecution. So, and there can be as much or as little. It can be just in courtroom. If I'm representing someone for a simple traffic ticket, the ADA, depending on how big the jurisdiction is not going to talk to me 10 times and write letters and go back and forth. I'm going to talk to him pretty much in court. And I'm going to say, look, my guy has no convictions. My guy cooperated with the officer. I've spoken with the officer. He's okay. I'd like to reduce this ticket from this to this. And if he doesn't have an objection, he can let me go to the judge, or he can say, sure. I prepare cases for trial. So one of the things that you do is you're going to review the witnesses, and you're going to review the evidence that the prosecution has and what you have, what the prosecution knows you have and what it doesn't know you have. If the trial comes, which is increasingly rare, the only person sitting next to you in the world is your attorney, and I represent them at trial. The big thing we do, however, is we negotiate plea bargains or sentences if there's a conviction or a plea. Most of what you hire attorneys for in a criminal case, we'll put aside minor things like traffic, is for a plea bargain. Even for traffic, if you think about it, if you've ever gotten a speeding ticket, you'll get a letter from a bunch of attorneys that'll say, you can hire me and I'll get you the best deal I can, and if you're innocent, I'll get a discharge. Now, some things they're very willing to drop. You have an expired registration, usually you can get that dropped. If you have excessive speed, usually you can't get that dropped, but you can get it reduced. They also decide to carry out an appeal. That should be not an appall. That is an appalling mistake. So we will change that when I revise the slides. Now, one of the questions I get is, how can I represent someone who is guilty? And the fact is, until the trial ends or till the judge passes sentence, my client is not guilty, because there is a presumption of innocence. Anybody that walks in my door, he is innocent in my eyes. I don't determine if someone's guilty. Now, I've met people that are morally reprehensible. If you think about the most dangerous thing you can do in society, with the greatest level of risk or death, it's going to be, shockingly enough, probably drunk driving. If you look at the number of people that are killed by other people in the United States in a criminal way, drunk drivers are going to pale everything else. There's just so many drunk driving fatalities. So I've represented a bunch of drunk drivers. Now, I don't think you should get behind the wheel of the car. I don't find that morally acceptable. However, you are entitled to representation. you are entitled to see if what you did, okay, will meet the statute that the state of North Carolina has passed, the drunk driving, the DUI statute, driving while impaired statute, to see if you're guilty of this offense. I have no duty to absolute truth, right? Although I cannot permit a lie in court or let someone lie in court. So I can't tell a lie in court. I can't say, my client never stabbed her if I know that he stabbed her. Neither, if my client has told me, yeah, I stabbed her, can I let him say in court, I didn't stab her. I have to only allow in front of the jury those things that I know to be true. I don't have to allow everything in front of the jury. But anything I do put in front of the jury myself has to be true. I represent my client zealously. I represent his interests within the boundaries of the law. I only go so far. I don't lie, I don't cheat, I don't steal, I don't bribe. Okay, that's my job. All right, there are two types of defense attorneys. Now, these numbers are a little bit, they're actually fairly current, but I'd say they're pretty low. You have private attorneys that are hired by individuals. Now, the typical rate is about $122 an hour. Now, take that with a grain of salt. There's all types of different criminal charges you can have. If you look at how much you make per hour for a speeding ticket when you represent someone, I'm going to assure you it's not $122 an hour. If you think about someone that you're representing in a drunk driver's case, you're putting more time in, you're charging more money, that's probably more. If you're thinking about representing someone in a horrific case like a murder, you could be talking, $300-$400 an hour. There are two basic types. Your private attorney, this is where you go out and you hire someone. So this is probably, I was trying to think today when I was prepping for this lecture, what crime in North Carolina has more private attorneys than public defenders? And I would say the only one that's probably close is drunk driving. We're talking serious ones, we're not talking tickets. Because it's a crime that the middle class and the wealthy commit in some large numbers. And they can afford private attorneys. Now, most people, however, who get arrested and face a criminal charge are poor. That's kind of unsurprising. They will get some type of public defender. I'll talk about different options of public defenders in a minute. But about 90% of criminal defendants need public defenders. And each state across the United States establishes their own rules, and sometimes within counties there are different rules. The conviction rates are relatively similar to private counsels, but I would take that with a grain of salt. Okay, what are your types of public defenders? Okay, well, sometimes you have, and North Carolina uses this, assigned counsel, where you have private attorneys. So suppose you are practicing in a small county like Robeson County or Mitchell County or Yancey County. The county may not want to hire a full-time lawyer to represent people charged, so they will go to a law firm within that county and they will say, okay, John Smith, we're going to hire you on a case-by-case basis for everybody that gets arrested in the county to represent them. And that would be an assigned counsel. You can also have contracting attorneys where you take all of those. So it can be just we're going to hire you for one, or it can be we're going to hire you for everybody. Probably the one that most people are familiar with is the public defender, and that is you flat out are working for the government. You're getting a check at the end of the day where the state of New York, say, is going to give you money and you work for the state of New York, and anytime there is a criminal charge and an individual is indigent, you're going to get appointed to represent him. Now, there are some states, the example I use is Wyoming, where let's suppose you get arrested and you get, it doesn't matter, assigned counsel, contracting, public defender. You're charged with a burglary and you don't have money, so you're entitled to an attorney. One's appointed to represent you. You win your case. You're found not guilty. You go, wow, that's great. Okay, and you walk out of the courtroom, and the state of Wyoming is going to give you a bill for how much money they spent to represent you, and you actually now owe that money. So now typically, even free public defender costs are reimbursed, even if they're found not guilty. The public defender. Public defenders are grossly underfunded and overworked overall. So one example I found, and this is about 4 or 5 years ago, just before the pandemic, there was a public defender in Lafayette, Louisiana, who was assigned in 1 year 194 felony cases. Now, if you were working an important felony, it would take you a minimum of 70 hours of legal workload. Let's just suppose that those 194 are not, not murder cases. Let's suppose so they're not 200 hours. They're not even high-level felonies. They're 70. They're mid-level felonies, something that someone would get a court appointed. It takes about 40 hours a week to represent someone. Okay, so there's 52 weeks in a year, right? All right, so there's 40 hours in a week. So you could represent 40 people, and that would be a lot. That would be, you could represent 52 people, and that would be a lot. You'd work every day, including Christmas, New Year's, 4th of July, and you could still represent adequately 50 people, but he had 194. So what does that mean? Well, that means that he didn't have twice as much as he needed. He didn't have 3 times as much. He had 4 times the caseload that was adequate. In fact, one full-time public defender was doing the work of 5 full-time attorneys. And I think what this shows you is that, and it's very common for governmental agencies and large corporations, large businesses to do this. They'll look at someone and say, we expect you to do this job. We want you to do more with less. We know you don't have adequate resources, but you got to do it. Well, you can get away with this for a little while, but one of the things that has happened is sometimes public defenders essentially say, I can't take any more cases. I'm absolutely full. And, I won't do it. Well, now you have no public defenders, you've got no budget, and you've got someone accused of a crime who is entitled under the Constitution to get legal representation. And, if you are cutting it at, a fourth of the money you need to spend to even get adequate representation, this should tell you how serious a problem it is. So, but it's a very hard sell. It's a very hard sell to go to the general public and say, hey, look, we're going to raise your taxes so we can give the money to attorneys to represent criminals. You'd be laughed off the ballot. But this is a serious problem. Okay, is the fix in? The extreme underfunding undermines our system, because the only way the system can work then is if the public defenders don't do as good a job as they could and do as fast a job as they can. So fast that people who otherwise might not go to jail, or evidence would have been discovered that they didn't do the crime, wind up going to jail. And the thing is, our adversarial system relies upon each side having some level of equality, being able to compete with each other in the courtroom to present evidence to determine if someone did or didn't do something. But if you say, well, one side, if the defense side now has only a quarter of the resources necessary, then essentially the fix is in. You're going to have a lot more convictions. All right, now let's talk a little bit about something, attorney-client privilege. Any communication made as part of representation between an attorney and his client is undiscoverable. No one knows. I've talked to many people who've told me things that are pretty unpleasant. And I've never said, hey, I just spoke to, and I'll make up a name, John Doe. And John Doe told me that he molests his child. I've never said that, even if John Doe told me. Now, if it was ongoing, if he said, hey, Jay, I'm going to molest my child, that's different. But if someone came to me and said, hey, 2 years ago, I robbed a bank, I can't call the police and I say, hey, the guy you're looking for robbing that BB&T 2 years ago, he's in my office, come arrest him. The Supreme Court has basically said, and every state in North Carolina is included in this, has said, what an attorney and a client talk about is privileged. It cannot be disclosed. Now, if the only exception is if it's a future crime. So again, someone comes to my office and says, "Hey, I bought some dynamite. I'm going to blow up the Brooklyn Bridge." I can call the police. The end of trials. Trials are getting rarer. In the 1980s in North Carolina, about 25% of cases went to trial. So I started practicing in the 1980s. And out of law school, I was in district court at least once a week. It was very, very common. By the time I became semi-retired, I became inactive on the bar, only about 3% of cases are going to trial. So all of a sudden, 97% of cases no longer go to trial. Trials are disappearing, which begs the question, why? And that's something you guys have to think about. That's something I'm not going to spoon feed you an answer. Now, after arrest and before trial. In North Carolina, when you're arrested, let's talk about what the procedure is. You are entitled to either an initial appearance or a first appearance. And those, you might as well just call them appearances. The initial appearance, and there's a North Carolina general statute that requires it, is after you commit a misdemeanor, they're going to bring you in front of a magistrate. The first appearance is usually you commit a felony and you get arrested, you go in front of a magistrate. But you'll notice, and the next slide is going to show it, that what happens in each is pretty similar. So your initial appearance, because it's a misdemeanor and relatively minor, we're going to tell you what you did. Hey, you got arrested for simple assault. You slapped somebody in public, you spit on somebody, simple assault. Usually we're going to determine if there was probable cause for this. Hey, you're charged with spitting on someone, but it was raining. No one saw you spit. The guy just said you spit. I don't think there's probable cause. Initial appearance will also set bail. So you get arrested for a misdemeanor. The magistrate will say, okay, that'll be a $3,000 bail, $300 cash bond. And often here, not always, appoint counsel. Now, first appearance, and that's for felonies, you're going to be informed, again, of your right against self-incrimination. You're going to get your right to counsel. You're going to get a copy of your charge. You're going to be able to review and inform the prosecutor if it's improper. You're going to set a pretrial release conditions, and it'll be bail, and schedule a probable cause hearing if necessary, although that's often waived. So, one of the things is this is where it can be important to have a private attorney. There was a case shortly before I retired where someone was arrested. The police officer charged him with a felony because the police officers and it was essentially because this man had a knife in a certain situation. And the statute actually read that if it was a gun, he could charge a felony, but if it was a knife, he had to charge a misdemeanor. Now, the police officer just mistakenly believed that it was any weapon, it was a felony. When I pointed it out during one of these appearances, the charge was modified, it was changed, okay, because it was an improper charge, from a felony charge to a misdemeanor charge. And that's kind of how important it can be to have an attorney, because all of a sudden you go from facing years in prison before you even begin your legal process to now you're only facing a couple months in prison. Okay, most people who are arrested for minor things. Drunk and disruptive, simple affray, which is fighting in public, something really minor. So most people, after they're arrested, will get ROR, and that is you're released on your recognizance, or released on your own recognizance. And we're going to let you go, and you just promise you're going to come back. And for most people, if you get charged with something and I say, okay, here's your trial date. If you miss your trial date, you're going to go to prison or jail, you're going to come back. Now, not for everybody. If you've got someone that is facing a life sentence, they're accused of a horrific crime like they burned down an orphanage, right? You better believe that we're worried about them coming back. They're not getting ROR. If we're worried about you coming back, we can make you set bail. Now, bail is an amount of money or property that you're going to pledge, and that means you're going to essentially give it to the state, and they're going to hold on to it, and you only get it back if you come to trial. So let's take an embezzlement case, you know, a major larceny case. You probably would get like a $5,000 bail. Now, what that means is you would go to a bail bondsman, you would give him $500, he would post the $5,000 bond, and then you would be out on bail. Okay, bail is a guaranteed right, but like a lot of things, there's always an asterisk. First of all, because the Constitution, as I've told you before, is a very brief document. So the part of the Constitution we're concerned about here is the Eighth Amendment to the Constitution, which says excessive bail shall not be required. All right, they put that in, by the way. A lot of things in the Constitution are in because the English were doing it to the American colonists, and the colonists didn't want their own government afterwards to do it to them. So, you know, quick example of that, the Third Amendment to the Constitution, which nobody pays any attention to, says you cannot quarter soldiers in people's private homes. Well, why is that in the Third Amendment? Because prior to the American Revolution, one of the ways that the British tried to, suppress the colonists was they stationed military troops inside people's homes. So one of the things they also did was they had very high bail. So Congress when the Constitutional Convention met, they said excessive bail shall not be confined. But here's the issue: what is excessive? Not defined. You're not even guaranteed that you get bail set ever. You could read that to say, you could read it very broadly. Excessive bail shall not be required. Well, if I said a bail which is infinite, which means you don't get out, that's excessive, right? Then if you read it in an expansive sense, the Eighth Amendment would require everybody to have an amount of bail, and it couldn't be excessive. But that's not how it's read. Typically, as I said, you pay a bail bondsman 10% of the amount, who keeps it, and then they post the bond. Now, the thing about this is another area where how much money you have really, really matters. If Bill Gates, the Microsoft billionaire, gets arrested, I don't care what his bail is. If it's $1 million or $10 million or $1 billion, he can cut the check. But if it's someone that's living paycheck to paycheck who has no assets, and you have to remember that 50% of America has negative equity. They owe more money than they have. Then bail can be a big burden for the poor. This is a probable cause hearing note. I found a judicial order for a probable cause hearing. This is held in front of a magistrate to determine if there's sufficient evidence. You're required in North Carolina to have this it's very often waived. And the interesting thing about the probable cause hearing is this is the beginning of where me as a defense attorney, I get to see what the prosecution has as evidence, because they have to offer some evidence that here it is, that there is sufficient evidence to keep this, in this case, this juvenile, under detention. All right, now, your book talks a little bit about grand juries. I don't have much experience with grand juries at all because we don't use them in North Carolina. Now, one exception to that is there can be a federal grand jury in North Carolina, but the state of North Carolina, our grand jury laws are, you could possibly use them for certain drug offenses, as I recall, but they're basically not used. So how does it work in most other places, or how does it work? Well, basically, before any arrest is made, a prosecutor impanels a grand jury, and you get these people come in, and very often it's secret, and he gets to present evidence to them to show that there is probable cause that a crime is committed. Now, let me explain how that works a little bit more. First of all, there's no defense attorney in the room. It's just the prosecutor presenting evidence. He can present evidence that would likely be kept out of trial because the defense would make a motion, hey, that's improper, that's triple hearsay or something. There's no cross-examination where you call a witness up and then they get cross-examined and you say, oh, well, that's garbage, they don't have anything there. Because of this, since there's no evidence that an individual is innocent ever presented unless the prosecution wants it presented, grand juries will almost always indict. Now, they are theoretically independent, but they almost always indict. The legal joke is a prosecutor can indict a ham sandwich if he wants to. That's how easy it is to use. And I think you should pay attention that anytime a grand jury doesn't indict, and sometimes you'll see this in cases that prosecutors don't want to prosecute. So this is what you could do if you were interested, and I'll leave this up to you. If you recall the riots in Missouri when there was a shooting in Missouri, the Missouri district attorney or whatever they were called impaneled a grand jury to investigate the police officer, and they didn't indict the police officer. Well, I think what would be very instructive would be look at how many grand juries he impaneled over his career and see how many failed to come back with a bill of true indictment. And I think what you're going to find in almost all cases is if the prosecution wants a bill of indictment, they can get it. So the prosecution, again, has great discretion. Are you going to be charged? Are we going to increase charge or decrease charges? Are we going to drop charges or are we going to prosecute? Now, sometimes they can simply say, this is a Latin term, it means basically not prosecute, nolo proseque, which means they're not going to go forward. Sometimes you hear the term dismissed. So if a case is dismissed with prejudice, usually you can't bring it back. But most of the time, if a prosecution dismisses charges, if they have evidence in the future, they can bring that charge back. And cases will suffer attrition because even though they have more resources overall than every private attorney, they have limited amounts of time and effort. So they will have to prioritize. What do they consider? Well, is there sufficient evidence to charge? And one of the things that goes on here, and this is the thing, one of the things as a defense attorney I find most egregious, is overcharging. Where a prosecutor, there's a little bit of evidence, but he knows that he'll never get a conviction for this charge. But let's suppose he could charge a felony larceny case. But if you look at the facts, it's a misdemeanor larceny. Okay? But there's some evidence to show it might have been a felony. He will charge the felonious larceny. And this is called overcharging. You steal 10 gumballs out of a machine over a 10-day period. That's a petty larceny. The prosecution might say, well, whoa. Technically, that's 10 separate larcenies or thefts. So I'm going to file 10 charges against you. And then I'll tell you what I'll do. I will plea bargain, and you only have to plea bargain to one. So they overcharge. It's kind of like a sale at a jewelry store. Jewelry stores are always having big sales where they say, 80% off. And how can they do that? Because they can raise the prices so high and then give you a big discount. Here, they charge you so high, then they give you a discount for a plea bargain. They'll decide if it's serious. The more serious the crime, obviously, the more action they take. Is it a murder? All bets are off. A rape? All bets are off. Is the victim cooperative and reliable? Very important. Is there a cooperative defendant, or is there powerful evidence? In other words, are they motivated to settle? These are all things the prosecution decides on when they charge, how much charge, will they drop. So in North Carolina, again, I have to change. In North Carolina, typically you have 4 options. I'm going to have to correct that slide quite a bit. Guilty, not guilty, nolo contendere, and Alford plea. So guilty, you did it, you committed the crime, you're willing to accept the sentence. Not guilty, I didn't do it. Let's go to trial. Nolo contendere, no contest. It's like a guilty plea, but it can't be used against you civilly. Alford plea is somewhat similar to that. Okay. So again, this is North Carolina's, and that's the cleaned up slide. Guilty, not guilty, nolo contendere, Alford plea. I'll let you look at that, and I will go back and edit out the other. Okay, as I said, 97% of federal cases, 94% of state cases are plea bargained. And there are 3 types of plea bargains you get. You can bargain over what you're charged with. Okay, dropping one or more charges is pretty common. You can bargain about your sentence. You're going to get active time, you're going to get a suspended sentence. You can bargain about the facts you have to admit to, and this could lead to civil liability, or what goes in the official record. This could be the difference between getting a conviction for an assault and getting a conviction for a sexual assault and having to be registered as a sex offender the rest of your life. So why do prosecutors plea bargain? You get a quick win. Saves you time, saves you money. Why do defendants do it? Because I look at my guy across the table from me and I say, here's the bargain. If you go to trial, you can face much harsher penalties. And very often the prosecution is threatening me with more charges or higher charges. It's also going to save people money. I can look people across the table and say, I can fight. If you got the money, I can fight for you, but this is going to be expensive. And sometimes you can rack up legal bills of thousands and thousands of dollars. This is from Human Rights Watch Sentencing Commission. It's somewhat old. It's 2012. But essentially, it's the average sentence for federal drug offenders, whether they go to a plea or a trial. Now, again, this is not. First of all, you can see, okay, how many take a plea? 24,000. How many take the trial? 700. So right there, you can see how rare trials are. But you'll notice that you take a plea, you get 5 years. You go to trial, you get 16 years. So, you could control this graph a little bit better. You could look at, okay, well, is it the fact that there were no offers for trial because the prosecution knew they were going to win and they were going to get a high penalty? Did the defense have nothing to lose, so they went to trial? Or is it that they overcharged and that was the lesson? There's lots of possible explanations, but I think one of the explanations here that is at least in part true is if you demand a trial, the prosecution will seek a much harsher penalty and you're liable to spend 3 times the amount of years in jail. Okay, on that less than cheerful note, came in right around 50 minutes or so. When we come back, we'll pick up with the next chapter. Other than that, have a happy and productive day, afternoon, morning, evening, or life if you never watch another one of these.